Start. An accused is protected not only when, on account of insanity, he was incapable of knowing the nature of the act, but also when he did not know either that the act was wrong or that it was contrary to law. Stop. The burden of proof that the accused was of unsound mind and as a result thereof he was incapable of knowing the nature or consequences of his act is on the accused, which would be evident from the illustration within bracket A of section 105 of the Evidence Act. Stop. The burden of proving the existence of circumstances to bring the case within the purview of section 84 of the L.P.C. therefore, lies upon the appellant. Stop para. Every type of insanity is not legal insanity. Stop. The cognitive faculty must be so destroyed as to render one incapable of knowing the nature of the act or that what he is doing is wrong or contrary to law. Stop. The prosecution in discharging its burden in the face of plea of legal insanity has merely to prove the basic fact and rely upon the normal presumption of law that everyone knows the law and the natural consequence of his act. Stop. The burden of proof of legal insanity is on the accused, though it is not as heavy as on the prosecution to prove an offence. Stop. In the recent judgment in the case of Prakash Nayi versus State of Goa, reported in 2023 5 ACC 673, the Hon'ble Supreme Court reiterated that standard of proof for the accused to prove his insanity is preponderance of probabilities and not beyond all reasonable doubt, and held para. The burden of proof does lies on the accused to prove to the satisfaction of the court that one is insane while doing the act prohibited by law. Stop. Such a burden gets discharged based on a prima facie case and reasonable materials produced on his behalf. Stop. The extent of probability is one of preponderance. Stop. This is for the reason that a person of unsound mind is not expected to prove his insanity beyond a reasonable doubt. Stop. Secondly, it is the collective responsibility of the person concerned, the court and the prosecution to decipher the proof qua insanity by not treating it as adversarial. Stop. Though a person is presumed to be sane, once there are adequate materials available before the court, the presumption gets discharged. Stop para. Section 105 of the Evidence Act, 1872, which places the burden of proving, has its exceptions. Stop. Though, as a general principle, the onus is upon the person accused to bring his case under the exception, dealing with the case under